Hello, John McConnon with UpsideDownRealEstate.com. Today we're going to talk about the Mortgage Foreclosure Consultant Act and how it applies to loan modification people and realtors. My source for this information is the Mortgage Foreclosure Consultant Act and the California Association of Realtors letters on short sale consultants and foreclosure scams. They're two separate letters. The foreclosure scam one is actually specifically the foreclosure scams and foreclosure consultant law. What do you need to know? Well, on July 1st, after a home is in foreclosure, after the notice of default is filed, you're going to have a $100,000 bond. Register with the Department of Justice. Probably have another bond, and you cannot do business with an authorization, or as the Act says, a power of attorney. Some realtors have argued that an authorization is not a power of attorney. I think it's a tough argument. But at some point, you're using that authorization to negotiate with the lender's loss mitigation department. And when you're doing that, you're acting via a power of attorney. You're trying to either get the terms of the loan changed or the lien released, a short payoff accepted. I just don't see how that's not a power of attorney. We can go into that on another video, or you can send me questions and we can discuss it further. I've already had this blog discussion with a few people on one of my blogs. I'm totally interested in someone trying to show that an authorization that allows someone to negotiate with a lender's collection department is not a power of attorney. In some other states, it is called a power of attorney. In some of the software, the authorization has a heading, power of attorney. So I think that is going to be a tough argument to argue that you can do short sales via a power of attorney, via an authorization and not a power of attorney. But nevertheless, we can go into CAR, and what CAR states. And CAR, in question 29 in the foreclosure scams and foreclosure consultant law, asks the question of whether the foreclosure consultant law applies to a short sale consultant. Your answer is it depends. And basically, it depends on whether the property is in foreclosure. Once the property is in foreclosure, their opinion is that, or their conclusion is that the foreclosure consultant law applies to short sale consultants. Then, of course, the question is, what's a short sale consultant? And for that, you can turn to the short sale consultant letter that they have, and you can see that a short sale consultant is somebody who works with homeowners attempting to help owners achieve a short payoff with the lender. Just food for thought. On future videos, we may even talk about what someone should do when they're negotiating with a lender and the notice of default comes out, or if they know ahead of time that they probably should not be using an authorization to negotiate with the lenders anyway, because they are acting as an attorney, as was put out by the National Association of Realtors in their magazine. I got it in my email over the weekend of May 22nd. Thanks. This is John McConnon, and I will talk to you later. Bye.